let me also welcome my august panelists. Thank you for your time, of course, for this beautiful discussion that we're going to have. To begin with, it's a very important topic in respect of the key trends shaping up for the commercial disputes and international arbitration framework in 2023 and of course beyond. So we will start this discussion with John, if I can start with you, with respect to how do you view the trends shaping up for the commercial disputes landscape as well as international arbitration framework?
Thank you very much, and good morning still, everyone. It's my pleasure to be here, and thank you for inviting me to participate with this august panel. I have a little different perspective because I think I'm the only government official on the panel, as well as the only one that focuses exclusively on intellectual property. But I think it's good to maybe just highlight a couple things since Justice Preeti Singh did a great job explaining this morning the evolution of India's intellectual property laws. And I think that underscores something that exists in all of our systems, is that our IP systems are constantly evolving. We're always responsive to industry, trying to figure out what adjustments we need to address market needs, to help dealing with, as you saw examples from a couple of our speakers today on advanced technologies and what type of added complexities that those bring into our system. And at the U.S. Patent and Trademark Office, so I've been there now 34 years, so I can definitely say we have evolved from when I started many, many years ago, where we only worked in paper and I hand wrote all of my work. But we've not only relied on these IT improvements, but also had to adapt and adjust as our technologies continue to advance. And a lot of that has to do with having strong, predictable, reliable IP rights, and not just the granting of those rights, but being able to enforce those rights through a variety of mechanisms, through the courts and through mediation, arbitration, and the mechanisms that we'll be discussing today. From a government perspective, I think it's worth just highlighting a couple things. At the U.S. Patent and Trademark Office, we have our own administrative trial proceedings, both on the trademark and the patent side. Those judges, though, do not get involved in the mediation and arbitration, but they care. They want to know what have the parties done in order to resolve issues before bringing it before the office and before the judge. So that is an important fact. It is something that they do like to see, that at least efforts had been made to resolve this before it gets before even our administrative trial judges. But then I think it's worth also mentioning or asking ourselves, what role should the government play in mediation and arbitration? And we heard the Attorney General, Sir, this morning talk about perhaps creating a working group, and having these rules to help govern how arbitration could take place. And I think that is an important step. And even looking in our own system and through the Federal Arbitration Act, where while we don't necessarily get involved in the discussions themselves, it does create this framework for validity and enforcement, ensuring that the judiciary enforces decisions that come out of arbitration, to being able to stay court proceedings, to be able to enforce arbitration awards, and so on. So I do think that creating some sort of mechanism to help support and bring consistency to the decision making and to how the results of arbitration are enforced is something that would be very much welcome. Just quickly, I thought I would turn again to the USPTO and looking at international trends that we signed last July, now almost a year ago, an MOU with the World Intellectual Property Organization, with WIPO, on partnering with them through their mediation and arbitration center, specifically focused on standards and working together to help raise awareness on those types of services that are available through the World Intellectual Property Organization to help stakeholders handle disputes, not just with standards, but across other spectrums within domain names and other forms of IP. So I think, and prior to coming to India, I was in the Silicon Valley, and I partnered with WIPO in their Mediation Arbitration Center on many programs to help raise awareness to this international body that is there serving, creating mediators and arbitrators across the world that are supporting this WIPO initiative. So I think that helps to bring more consistency, predictability, reliability into our systems, and something that we look very much to support. And lastly, just as I turn it back over, just my role here in India, this event actually covers pretty much all three of my pillars, which one is the government-to-government work that we do to help inform IP laws and help to support strong, predictable, reliable IP rights that can be enforced. Also working with industry, like many of my colleagues here on the panel and those of you in the audience, advocating on your behalf, being responsive to your needs, and then also helping to understand how the different systems work, not just the court systems, but the different arbitration mediation laws work throughout South Asia. And then thirdly, much like our MOU with WIPO, is working on public engagement and outreach and education, raising awareness to many of the things that we do collaboratively with the Indian government and promoting awareness across the spectrum of IP. I'll stop there. Thank you very much.
Well, John, heartening to hear about the sort of awareness that you are spreading, working with governments. Allow me to come to Neeti for her initial impression of the commercial disputes trends and the international tax framework, arbitration framework.
Thank you, Mannu. Firstly, thank you, Mannu, for that question. Though I must say it's so broad a question, I could go on for the next 27 minutes that we have, but I'll try and restrict myself. Also, thank you to ET Legal World for having me here. I think the question of what are the top trends, like I said, I could probably talk about hundreds of them, but I will focus on 4 trends of what we're seeing in the dispute resolution and in arbitration specifically in India and globally. First, of course, would be the use of institutional arbitration. I would be failing in my duty as a representative of MCIA and as a representative of institutional arbitration to talk about how that is now picked up. And I think where India was lacking to see that ad hoc still ruled the world of how we resolved our disputes, definitely bigger disputes, smaller disputes are now getting into institutional arbitration. And in India itself, we have more than 30 arbitral institutions which are doing a great job. I think the second trend I want to talk about is the use of ODR. This is something, of course, a concept which had existed for a long time, but in India, I would say was probably slow in adopting it, but not anymore. We have Rajneesh in the room who's there, who's heading the CADA, one of the ODR platforms and successfully doing things, and probably Rajneesh can talk about more as to what they are doing in the top trend of disrupting the market with the use of ODR. I think third I want to talk about is what I picked up from Justice Singh's speech in the morning, and she spoke about the untapped potential of women. In arbitration, I always say that women can play a very important role. She gave you a figure of how you join, women are there, and then by the time they are in the 40s and the 50s and time for them to become partners of firms, you don't see them. I think in arbitration, we're seeing that women who were in either corporate or who were doing litigation practice, but for one reason or the other, they had to discontinue with their career, are taking up more and more arbitrator appointments. And I can tell you from our experience itself that MCIA in the last year itself appointed 33% of their arbitrators as women, which is 1 out of every 3 appointment was a women arbitrator. And I think the last and the fourth global trend, I would say, is use of arbitration for sector-specific dispute resolution. We had Daniel who spoke about renewable energy. We had John talk about IP, Justice Singh talking about IP. I think there are very many other fields where you're now seeing that what arbitration was probably not being used to resolve disputes is now becoming more popular for resolving quicker, efficient, effective dispute resolution. So that, I would say, for me, are the topmost 4 trends of arbitration right now. Thank you.
Well, thank you, Neeti, for laying down that 4 trends that are going to be shaping the world of international arbitration and commercial disputes. Kinshuk, if I can come to you for your comments, specifically on a trend about the suitability of the energy disputes with respect to arbitration?
Thank you, Manu, and good morning, everyone. So, you see, there has been a lot of conversation of late about energy transition in the backdrop of climate change and climate control. Investors, governments, and across the, the energy ecosystem, you will see players getting more and more increasingly getting conscious of the energy transition and the climate, the climate control and the regulations that are being imposed on them. Because this is something which has sort of emerged more recently, the existing contracts or the existing agreements would probably not have enough as far as environmental concerns are concerned. So there is a gap there. What is happening, therefore, we need to understand that climate, the conversations and the problem, the climate control problem itself, it is beyond, it's a larger problem which is affecting communities. And it is not essentially something which is only confined to two interest groups. Currently, the arbitration and the procedures that we have worldwide that are followed, that are mostly Anglo-US, where we have an arbitrator, there are two parties which they represent different interest groups. If you ask me whether this current model is suited to decide these disputes of climate change, then my answer to that would be singularly this is ill-suited. Because there is a representation that is required, a larger representation of the community which is getting lost in this process. Because the current procedural system that we have when it comes to arbitration, the arbitrator performs the role of an adjudicator merely. There is no, the role that an arbitrator performs is not investigatory, it is not inquisitorial. So there is material that is placed in front of the arbitrator. Either interest group will have their representations in terms of maybe expert opinion who is going to present the stories and the narratives of each of these two contracting parties. Where does the interest of the community go? Now, one could possibly argue that when we are talking about an investor-state dispute, which is common in these kind of things, when you have state as one of the parties, the state is including the interest of the nation or the community. It subsumes that interest. But even so, I think that that representation is not quite adequate because a state does have its own political, backing. It will have its own policies, its own politics that it has to sort of adhere to. So maybe a system can be devised, and of course this is very futuristic because energy transition disputes and climate change, etc., this is something which is long term. This has only just begun, and we are probably going to be seeing more disputes in the, in the coming years than we are seeing now. But perhaps the role of an arbitrator can be expanded a little to make it more meaningful to adjudicate the dispute in real sense.
Okay, Kinshuk, so you are basically saying that there's a need for more representation, and the disputes, energy disputes, are certainly suitable for the arbitration framework.
Well, if I have to sum up, then yes. I mean, the procedure could be broadened a little bit in terms of the arbitrator's role.
All right. So let me have a quick view from Vani. Vani, your company is a big energy company. So if you could add your comments in respect of how do you see the energy transition trends as one of the important trends for commercial disputes and international arbitration?
Good morning, everyone. I think firstly I would like to put in the disclaimer that the views shared on this platform are personal and not a representation of the company. With regard to energy transitions, couple of factors that Kinshuk also spoke about. The trend in the last 2 to 3 years has changed substantially for this particular sector. We see new issues coming up which we've never dealt with. I think previously, like Dr. Daniel Sharma spoke about external factors in the energy sector. We were dealing with force majeure, pandemic, And today we are dealing with external factors. And when I say external factors, there is new set of regulations which are evolving, and we identify as an organization, we identify as an industry that there are gaps. There are gaps in terms of addressing climate change. There are gaps in terms of addressing sustainability reports and the disclosures which are being made by the companies, and the recognition that these sustainability reports are receiving across the globe by various organizations. So when I say gaps, this also, the reason why I say gaps is because at some point of time there are going to be disputes around it. And how is arbitration, just like in civil litigation or criminal litigation, how is arbitration going to address it? Because those gaps are going to, when it comes to disputes, these gaps are going to show up. And it is not that, today you can find a one-stop solution. There is no solution. It is a constantly evolving field. We should recognize it, that today, maybe 20 years back, we were talking about solar energy. Today, we are talking about different means and ways of renewable energy. It is constantly evolving as we talk about. The governments recognize it, the governments feel the need to address it at international forums, at national forums, and across the world, I would say the trend is changing. So one, when I talk about energy transitions, I refer to that. Also, I heard this term, external factors. How external factors influence arbitrations which are ongoing. Also, one very big trend in this particular sector I have noticed is with changing time, there are a lot of mergers and acquisitions which are happening. And a lot of time, your key witnesses are also moving on to your competition. And we are talking about multi-million-dollar disputes over here. So how do you protect your interest as an organization? And how do you address this issue is a very big concern for legal teams, and as well as for external counsels, that how do you make sure that, because these are very technical experts over here that we're talking about. So when it comes to arbitration, how do you address these issues? And also in this fast evolving, I would say, renewable sector, it's an issue that we really need to be aware of, mindful of, and also look at innovative ways to address it.
Okay, innovative ways to address it. I think innovation is very important name in this game. But before we take this discussion forward, I just would like to quickly throw the floor, surprisingly, to the audience. If someone has any question as of now, we would be willing to take that.
Good afternoon. I am Navneet Goyal. I am part of ESRI India. So my query is regarding, do you see any issues that legal fraternity will be facing for net zero compliances? Net zero target, carbon credits?
Okay, that's a very interesting question. Does anybody, we have the two GCs, two dynamic GCs, innovative GCs, three beautiful lawyers, and of course, two great experts, IP, of course, and yes. So please, anyone would want to take this question?
Okay, so, and I'll share experiences from across organizations. I was previously working for an organization where manufacturing, and supply chain issues were present. I currently work for a listed entity where, my sustainability reports and my ESG governance is equally important. I think for us, the challenge to meet our net zero targets lies a little bit in how we are clarifying our regulations a little bit, because there are no materialities, there are no thresholds. I think it's important for us to be clear in terms of what does it mean for corporations or organizations, number one, to achieve targets. So please clarify thresholds or materiality, number one. Number two, I think some of the challenges we have and we struggle, when manufacturing is easy, how much water do you consume, how much plastic do you consume, and how do you neutralize some of those things. It's far tougher to be in a services industry like ours and then try to achieve some of these targets, because we don't understand. I mean, we recycle what we use, right? But how are we really contributing meaningfully to net zero? So I think it would be really helpful for us to sector specialize and create materiality thresholds so that it is meaningful when we are trying to be sustainable. Having said this, in practice or practicality, I don't know if we really have a culture and purpose of sustainability. I mean, and I'm equally guilty of this, right? We take so many printouts. we still use a lot of paper. So I think one of the things that we also need to really inculcate is a culture of sustainability. Can we really think of being sustainable as organizations and not just what we do as our CSR initiatives? So that would be some of my views.
Okay, please, Vani, please.
So to answer your question, yesterday we did release our sustainability report, and in that, we've made a commitment that we'll be net zero by 2030 for both the organization that we've created, which is GE Vernova, which is going to be a renewable energy company, as well as for GE Aerospace. And we have actually provided clear targets as how we intend to achieve it. We've been, I would say, industry leaders in both these fields, and we're also looking at actively testing, I would say, biodegradable aviation fuel, as well as different means to achieve renewable energy sustenance in this field. So for both those, and these are public disclosures that we have made, and a commitment we have done around 5 years back as a company for both these organizations.
Okay, we will take one more question before we go back to the discussion itself.
Sure.
One more question from that gentleman.
Thank you so much. My name is Rajneesh Jaswal. Hi, my name is Rajneesh Jaswal. This is not so much a question, but a comment, and thank you, Neeti, for bringing this up. I belong to an organization called CADR ODR, Online Dispute Resolution. We've got the Commercial Dispute Conclave ongoing, and we haven't spoken about ODR. It's just a quick comment. ODR today has a place in commercial disputes and a number of areas. Please reach out to me if you have any questions around it and how ODR can help in your commercial dispute resolutions by taking dispute resolution to your doorstep. Thank you.
Thank you. Thank you so much. I think this is a very important point raised by Neeti, as well as a trend of the online dispute resolution, which is a pretty hot trend these days. But I'll come to Preeti again, and thank you for answering the question of that gentleman. Preeti, there are risks which are emanating from supply chain disruptions. How do you view those risks getting resolved to the arbitration route?
So before I answer some of the supply chain issues, I'd like to also comment a little bit on the energy piece, as well as Neeti's very pertinent point on diversity as a trend. So I really think, Neeti, that it is an important and increasingly interesting emerging trend that there is a need for a diverse set of arbitrators. Interesting in terms of how you're looking at it as an institution. I would also be curious to see if we make some strides in this area to see if there can be some limits on mandates or some requirements, and to see if that has any traction. On the energy piece, I see a lot of EU states withdrawing from the Energy Charter Treaty. I think one of the key things to be mindful there is to look at some of these sunset clauses. So whilst Russia sort of chose to move out in 2009, its sunset clauses still remain active till 2029. So I think we have to be careful sometimes when we sign up to these treaties. I don't think the treaty has been really effective. I think a lot of disputes, as you rightly said, go out of or have public policy requirements, and therefore states want to govern that and have some exclusivity there. And therefore it's not really been an effective mechanism for arbitrating or arbitrability of some of these disputes. Supply chain disruptions have now been consistent for quite a few years. I think they started during the pandemic. At that time, I was working for a manufacturing organization where we were setting up new factories, new plants. We were having delay in machinery and manpower, along with commodity issues. Commodity issues continued, and the geopolitical Russia-Ukraine situation didn't help it either. I think some of the things that we need to be mindful of when we are thinking about arbitration and some of these contractual disputes that we will have with the supply chain disruptions is, and the gentleman there spoke about technology. I think we should also think about technology when it comes to logistics and supply chain, and how much we leverage technology when it comes to those sort of things. I think the other thing is to also think of reshoring our contracts to make sure that, you know, if it's China that needs to supply, then what is the alternate supplier that can be close to logistically that can provide into our contracts, permit for such variations or alterations. I think we also need to start thinking a little bit about what are our supply chain related disclosure norms, right? And how some of those things impact disputes or don't impact disputes. And about how we are able to make an effective transition even in supply chain to you know, green energy or greener supply chain methodologies. I remember recently we had a UK newspaper ask us as CRISIL for a comment on a client's green transition plan. So we've done a report and an analysis saying that, you know, we've reviewed our client's green transition plan, and this is our analysis of, you know, how the funds are going to be used, and we'd put out this report. So I think there's some reputational risk as well when you are, because the entity didn't end up really sticking to its green transition plan, and we were being asked as auditors or people who reviewed their report or who gave a stamp as to what are some of those elements, and how do you stand behind your report. So we have to be conscious in some of those senses. I think, you know, arbitration as a methodology, one of the key things that we face in India is really enforceability. And I think we should really think about enforcement and whether we need reforms when it comes to enforcing foreign awards. There's a lot of conversation and debate around how India is not necessarily an easy jurisdiction for enforcement of foreign awards. And I think the last final point that a lot of us have been thinking about as lawyers, especially as people who draft contracts, is first we had the debate about place and venue, right? And now I think we talk about the proper law of the arbitration agreement. And I think the Anupam Mittal versus Westbridge conversation comes up frequently, because now we're very conscious of when we are drafting these contracts, whether we are thinking through about what is the proper law. And a lot of us relied on drafting where we said, oh, but the proper law of the arbitration agreement would be the governing law of the contract, and never ever thought that there could be a debate about whether a particular topic is arbitrable or not. And again, to Kinshuk's point, a lot of states have public policy on certain disputes or certain matters that cannot be arbitrated. So I think we should think of some of these things as well when we are thinking about. And I think Dr. Sharma made the point on choice of law, which was, I think, a very critical and pertinent point, because as an in-house counsel working across geographies, choice of law can sometimes determine whether a dispute is arbitrable, not arbitrable, and ease of mechanism. And of course, Neeti, I always say this to you, institutional arbitration needs to find more takers, especially Indian institutional arbitration. I think you guys do some great work at the MCIA, and we need to really encourage contracts to have institutional arbitration and Indian institutional arbitration.
Okay, thank you so much for extremely elaborate and detailed, comprehensive answer, Preeti. And thank you for, I think I have held back two of the lawyers so far, and I hope I'm not taken to task by either of them. But yeah, so it's an important area that we are going to jump in, and that is India has been trying a lot to become a global arbitration hub, and there is a significant road ahead so far. So let me quickly seek views from Vijay, who has been extremely patiently hearing.
Yeah. Good morning, everyone. See, we recognize that India is still not an arbitration hub. So I would like to highlight what the Arbitration Act has done and what more is required to be done to make India a global arbitration hub. See, in the recent years, from we take 2015 onwards, there have been 2 amendments in the Arbitration Conciliation Act, 2015 amendment and 2019 amendment. The global concern was primarily that duration of arbitration in India was uncertain. How long will it take to finally render award? That was uncertain. Other issue was too much judicial intervention. It was complained that court has hijacked the arbitration proceedings at all stages. And third was enforcement regime. So the government has decided to address all these issues, and from 2015 and 2019, certain amendments have been carried out, which has primarily addressed, but which is not enough. Like that, so far as duration part is concerned, still there needs amendment. There has been amendment that the arbitration has to be decided within a period of 1 year, so far as domestic arbitration is concerned, Section 29A of the Arbitration Act. But so far as international commercial arbitration is concerned, the phraseology used is endeavored to complete within a period of 1 year. That is not enough. So if a global player who opts Indian jurisdiction, and of course in India seated Arbitration Conciliation Act Part 1 will apply. So he will be conscious that there is no time limit. The duration of arbitration is not known. So that is a problem. It requires to be amended to make it at par with domestic arbitration. It has to be concluded within a period of 1 year, 6-month extension, and thereafter one can apply to the court if they want further extension. Other important aspect is challenge. Of course, the amendment has done good things by amending the definition of court. See, in Arbitration Act, the court has been defined differently for different purposes. Like for the purpose of appointment of arbitrator, court is different. For the purpose of if somebody is going to apply for interim measures, the code is different. For challenge to award, the code is different. But for the purpose of international commercial arbitration, now it has been recognized the court will be the High Court. So it means that the suspicion, a doubt that where one will have to apply for different relief in case some disputes arose, that has gone. Now, for the purpose of international commercial arbitration, High Court would be the competent court. Now, so far as challenge to award is concerned, of course, foreign seated award cannot be challenged within India. That's a good step. But still, domestic award, even if that is international commercial arbitration, that is subject to challenge. But one good thing has been done, that patent illegality clause has been taken out. Now, so far as enforcement regime is concerned, of course, if a foreign award is come to India for enforcement, of course, that cannot be challenged in India, but still, the grounds for challenge, if you see the grounds for challenge and award under Section 34, and why an enforcement of an award should be refused by the court under section 48, those are identical. And if foreign award is filed in Indian courts for enforcement, then the award debtor has right to take objections that this award should not be enforced in India on similar grounds. And when such applications are filed, court will have to adjudicate. There is no time limit. Like in section 34, endeavor has to be made to decide objection within a period of 1 year. But in 48, section 48, when somebody questions the enforcement that such awards, foreign awards should not be enforced, there is no strict time limit. So my suggestion would be that there has to be some time limit, that the court should decide an objection why and foreign awards should not be enforced in India within a period of 1 year. That could be a good change. Other can be that, like in Delhi High Court, Justice Pratibha Singh was mentioning, there is separate IP division, which has really expedited the things. Where is it possible for the legislation to establish separate enforcement and recognition of foreign award in different high courts who will deal with all the objection concerning foreign award and its enforcement, and finally they will deal with the enforcement of an award. That will be great. Since there are lots of things will have to be added, but we are running out of time.
Sure. So the last point that we will quickly want to discuss is with the last panelist. I'm so sorry to hold you back.
No.
So Raunak, would you want to add on in respect of what Vijay has already said in terms of the timeline? Yeah.
Can you hear me? Since I'm coming in last, I'll keep it very short. I think one of the largest and very standard issues that investors or foreign clients come to us with is, look, we've been in court, or we are going to be in your courts for the longest time. What is the best way, or what is the solution around it? Well, at the moment, like everybody else is, sort of raised that, and Vijay in particular is raising that objections, enforceability, all of this has taken so long and so long in court that deters investors from actually coming in here. So one of the solutions I've been thinking about, and we really discussed this internally as well, and give it 2 forums where such solutions are sought for, is specialized arbitration benches. So whilst we've set up commercial courts and commercial benches, and they are hearing arbitration matters as well, why not have a separate independent arbitration only bench? And the reason why I say this is because if you have such a bench, the time taken for enforcement or execution of awards will perhaps reduce significantly, because those specialized benches will then be hearing only those matters and dealing with only those issues. The other aspect I deal with insofar as arbitration is concerned is Neeti's domain, actually. We must really increasingly use institutionalized arbitrations in India, and I think London, Singapore, Dubai as well have been examples for all of us, and I think we have robust institutional arbitration institutions in India, and I think increasing use of that would perhaps sort of reduce the concerns that investors have. And of course these institutions have their own work cut out to ensure that they are in fact as robust or as strong as some of these international institutions are. But I think as Indians and as people here, we must ensure and support such institutional arbitrations.
Okay.
Thank you.
Raunak, thank you so much for your last comments, for your last words, so to say, and quick, short words. Before we close, we just want to again thank our eminent august panelists, each one of us, each one of you guys, and also the audience. If we have time, we can just sneak in one question, and please, if you can just limit to a sentence or that, it will be great.
So a very short question, in fact 2. One for Neeti. Are you looking at starting mediation as well? Because there are no mediation rules as such with MCIA. And one for John. Recently there has been this controversy regarding panel stacking and retaliation against its own judge by USPTO in that Nike versus Adidas case. How do you see that affecting the or changing the course for dispute resolution at USPTO?
the short answer is that not yet. We don't have a mediation rules yet, but is it something which MCIA is considering? Yes, of course. Do we support mediation? Absolutely. Why don't we have it then till now is that I think for MCIA, it's one step at a time. We are trying to bring in a culture of institutional arbitration. Trust me, it's not easy yet. We're still talking about how people need to move to institutional arbitration. I think we're still a little bit premature on moving to institutional mediation. But we wholeheartedly support it, and probably in a couple of years, you'll see us venturing into that direction as well.
And I can be very brief and just say I think it's too early to tell. So just not sure yet what the impact will be, and maybe we can talk more offline about it. Thanks.
Sure.
Thanks.
Very brief answer.
So John has had the first word, and he has also now the last word. Thank you so much again to our panelists and to our audience for patiently listening in. Thank you so much.